California state law has passed and is now in effect SB9, which is part of the Senate's Building Opportunities for All housing package that was created to address the severe housing shortage in California. Since this was passed at the state level, guess what? It applies right here in Santa Cruz as well. Hi, I'm Shemeika Fox, your Santa Cruz real estate expert, and here is everything you need to know about SB9 and how it affects you right here in Santa Cruz. SB9 was signed by Governor Newsom and chaptered by the Secretary of State. This bill went into effect on January 1st, 2022. Please note, and this is important, that this is a new process that is subject to further interpretation by the State Department of Housing and Community Development, HCD, and code amendments are expected in early 2022. When code amendments and/or additional guidance are published, the city will update criteria and procedures accordingly. Therefore, the information in this guide is subject to change under the new state law. SB9 makes two changes to state law. It allows homeowners in most areas around the state, those zoned for single family, to divide their property into two lots, thereby increasing opportunities for home ownership in their neighborhood. And it allows two homes to be built on each of those lots, with the effect of allowing 4 homes in areas that previously only had 1 home. What does SB9 allow? SB9 allows for a proposed housing development, including a minor land division, to divide 1 lot into 2 containing no more than 2 residential units on a single lot within a single-family residential zone to be considered ministerial if it meets the below criteria. The term ministerial means that no discretionary review is required, i.e., no use permits, design permits, or tentative map approval. Therefore, SB9 projects must only obtain non-discretionary permits such as those that are required through the Building, Fire, Water, and Public Works Department, and must comply with non-discretionary requirements. What is a housing development? A housing development is a project that includes no more than 2 units on a single parcel. This can include the construction of up to 2 new units, the legalization of up to 2 existing units, or the construction of 1 new unit to 1 existing unit. There are also some exceptions for an ADU to be considered as the 3rd unit on 1 parcel. Can you split your parcel and propose 2 housing developments on each new parcel under SB9? Yes. Under SB9, you can split your parcel, assuming it is in an R1 or RS zoning district, into 2 parcels and create a housing development on each lot with a ministerial, non-discretionary permitting process. However, the project will need to meet the qualifying criteria for both a housing development and a lot split as described below. How do I submit an application for an SB9 lot split and/or housing development? First, you'll want to review the qualifying criteria to confirm that the project meets all of the requirements. If you've determined that your project is actually eligible, you'll need to contact the building department for information on the building permit process. If your project includes a lot split, please also make sure that you contact the Public Works Department for information on submitting a parcel map for review and recordation. Here is some basic information on the qualifying criteria for a housing development or lot split. The development must occur on a legal lot. The development or lot split is not located on a site that is in any of the following: either prime farmland or farmland of statewide importance as defined pursuant to United States Department of Agriculture land inventory and monitoring criteria as modified for California and designated on the maps prepared by the Farmland Mapping and Monitoring Program of the Department of Conservation, or land zoned or designed for agricultural protection or preservation by a local ballot measure that was approved by the voters of the jurisdiction. 2. Wetlands, as defined in the United States Fish and Wildlife Service Manual, or within a very high fire hazard severity zone as determined by the Department of Forestry and Fire Protection, or within a high or very high fire hazard severity zone as indicated on maps adopted by the Department of Forestry and Fire Protection. This subparagraph does not apply to sites excluded from the specified hazard zones by a local agency or sites that have adopted fire hazard mitigation measures pursuant to existing building standards or state fire mitigation measures applicable to the development. Next, a hazard waste site or a hazardous waste site designated by the Department of Toxic Substances Control to the Health and Safety Code, unless the State Department of Public Health State Water Resources Control Board or Department of Toxic Substance Control has cleared the site for residential use or residential mixed uses. The next one is if it is within a delineated earthquake fault zone as determined by the state geologist in any official maps published by the state geologist, unless the development complies with applicable seismic protection building code standards adopted by the California Building Standards Commission under the California Building Standards Law, or if within a special flood hazard area subject to inundation by the 1% annual chance flood, 100-year flood as determined by the Federal Emergency Management Agency in any official maps published by the Federal Emergency Management Agency. If a development proponent is able to satisfy all applicable federal qualifying criteria in order to provide that the site satisfies this subparagraph and is otherwise eligible for streamlined approval under this section, a local government shall not deny the application on the basis that the development proponent did not comply with any additional permit requirement, standard, or action adopted by the local government that is applicable to that site. A development may be located on a site described in this subparagraph if either of the following are met. The site has been subject to a letter of map revision prepared by the Federal Emergency Management Agency and issued to the local jurisdiction. Or 2, the site meets Federal Emergency Management Agency requirements necessary to meet minimum floodplain management criteria of the National Flood Insurance Program, or within a regulatory floodway as determined by the Federal Emergency Management Agency in any official maps published by the Federal Emergency Management Agency unless the development has received a no-rise certification in accordance with federal regulations. If a development proponent is able to satisfy all applicable federal qualifying criteria in order to provide that the site satisfies this subparagraph and is otherwise eligible for streamlined approval under this section, a local government shall not deny the application on the basis that the development proponent did not comply with any additional permit requirement, standard, or action adopted by the local government that is applicable to that site. Lands identified for conservation in adopted Natural Community Conservation Plan pursuant to the Natural Community Conservation Planning Act or other adopted Natural Resource Protection Plan. Habitat for protected species identified as candidate, sensitive, or species of special status by state or federal agencies, fully protected species or species protected by the Federal Endangered Species Act of 1973, the California Endangered Species Act of Division 3 of the Fish and Game Code, or the Native Plant Protection Act. Or lands under conservation easement qualifying criteria for a housing development. The lot is located within an urbanized area or urban cluster, or within a city that has an urbanized area or urban cluster. All parcels within the city of Santa Cruz comply with this requirement. The project does not involve the demolition or alteration of housing occupied by a tenant in the past 3 years or any affordable housing, rent-controlled housing, or housing that was withdrawn from rent within the last 15 years through the Ellis Act. During review of your application, city staff will confirm that the unit is not registered with the Rental Inspection Program and will confirm that an affordable housing agreement is not recorded on the property. Additionally, the property owner will be required to sign an affidavit confirming that the housing to be demolished is not rent restricted under any local, state, or federal agreements, and that the housing has not been rented within the last 3 years. If it is found that an existing housing unit meets any of the above criteria, or the property owner is unwilling to sign the above described statement, the unit will not be permitted to be demolished or altered. The project does not involve demolition of more than 50% of the existing exterior walls of an existing dwelling if the site was rented in the last 3 years. Plans submitted for building permit issuance shall include details showing the extent of demolition, including calculations and dimensions on walls to remain, the wall studs, existing window door openings, existing window and door headers, and existing top and bottom wall plates shall be preserved in place and shall not be removed and reconstructed with the same or similar materials, or reinforced through techniques such as sistering, regardless of the state of decay or non-compliance with building code requirements. The site is not located within a historic district, is not included on the State Historic Resources Inventory, or is not within a site that is legally designated or listed as a city or county landmark or historic property or district. A project utilizing an SB9 lot split may include a maximum of 4 units between the 2 lots. One or both lots may remain vacant. However, one lot cannot be constructed with all 4 units, which would render the other vacant lot unbuildable. If a housing unit is demolished, then the demolition will be subject to replacement housing requirements of SB 330, which includes the construction of a replacement housing unit if it is determined that the house to be demolished is occupied by a low-income household. Then the replacement unit may be required to be a restricted, affordable unit. The maximum number of units per SB9 parcel is 2 units and 1 ADU. See below section on accessory dwelling units. SB9 units may be mapped and sold as condominiums. However, an ADU may not be mapped as a separate condominium parcel. Note that there are some exceptions to this requirement under state law for nonprofit developers. The lot to be divided must be zoned RS, residential suburban, or R1, single family residence. The lot to be divided was not created through a prior SB9 land division. The property owner must occupy one of the housing units as their principal residence for a minimum of 3 years from the date of the approval of the SB9 land division, unless the applicant is a community land trust or a qualified nonprofit corporation. As part of the parcel map review process, city staff will require that the property owner sign an affidavit to assure compliance with this requirement. Neither the owner nor anyone acting in concert with the owner may have previously subdivided an adjacent parcel through an SB9 land division. As part of the parcel map review process, city staff will require that the property owner sign an affidavit to assure compliance with this requirement. Each new lot must be a minimum of 1,200 gross square feet. The land division must result in 2 new lots of approximately equal size with a maximum 60-40 split. The land division must not involve the demolition or alteration of housing occupied by a tenant in the past 3 years, or any affordable housing, rent-controlled housing, housing that was withdrawn from rent within the last 15 years through the Ellis Act. During review of your application, city staff will confirm that the unit is not registered with the rental inspection program and will confirm that an affordable housing agreement is not recorded on that property. Additionally, the property owner will be required to sign an affidavit confirming that the housing to be demolished is not rent restricted under any local, state, or federal agreements, and that the housing has not been rented within the last 3 years. If it is found that an existing housing unit meets any of the above criteria, or that the property owner is unwilling to sign the above described statement, the unit will not be permitted to be demolished or altered. The site is not located within a historic district or not included on the State Historic Resources Inventory, or is not within a site that is legally designated or listed as a city or county landmark or historic property or district. The city may only impose objective zoning standards, objective subdivision standards, and objective design standards on an eligible 2-unit development project. Despite any objective standards in place, the maximum required interior side and rear yard setbacks shall be 4 feet. No setbacks are required for existing structures or new structures that are constructed in the same location and to the same dimensions as an existing structure. The terms objective zoning standards, objective subdivision standards, and objective design review standards mean standards that involve no personal or subjective judgment by a public official and are uniformly verifiable by reference to an external and uniform benchmark or criterion available and knowable by both the development applicant or proponent and the public official prior to submittal. These standards may be embodied in alternative, objective land use specifications adopted by a local agency and may include, but are not limited to, housing overlay zones, specific plans, inclusionary zoning ordinances, and density bonus ordinances. Objective standards must not physically preclude the construction of 2 units of at least 800 square feet. This does not include a property owner's reference for a specific location on the lot. If there's a question about the buildability of an 800 square foot unit in a location that meets objective standards, the applicant shall be required to provide such evidence of such determination, including obtaining concurrence from any other department, division agency, or professional as necessary. A new lot created by an SB9 land division shall comply with the objective standards in the subdivision ordinance so long as such standards do not preclude a land subdivision that meets the lot requirements above and allows for a project of 2 lots with 2 units on each lot of at least 800 square feet per unit. The city shall not require corrections of nonconformities as a part of the SB9 process. Nonconformities are features that were legally constructed prior to the current ordinance that have become nonconforming due to subsequent ordinance amendments. Unpermitted features may be required to be resolved as a part of the building permit or parcel map process. Parking, this is always a good one. 1 off-street parking space per unit is required unless the project site is located within half-mile walking distance of a quality transit corridor or a major transit stop, or a car share vehicle is located within 1 block of the parcel, in which case no off-street parking is required and existing off-street parking may be removed and not replaced. That's a big one because parking is always really hard in Santa Cruz. These criteria are defined below and are also mapped on the Santa Cruz City's Santa Cruz map system. A quality transit corridor is defined as a fixed route bus service with service intervals no longer than 15 minutes during peak commute hours. These areas are mapped on the Santa Cruz City's GIS in the major transit stops buffers and car share location buffers layers. Major transit stop definition. An existing rail or bus rapid transit station. The intersection of 2 or more major bus routes with a frequency of service interval of 15 minutes or less during the morning and afternoon peak commute periods. Car share definition. The city defines 1 block as 500 feet. These regulations apply inside and outside of the coastal zone until such time that a code amendment is approved with differing requirements. Accessory dwelling units or ADUs. ADUs are permitted as part of an eligible housing development and must comply with the regulations in the zoning ordinance and state law with the following exceptions. A maximum of 4 units total are allowed in a housing development project that utilizes an SB9 lot split. ADUs count towards the total of 4 units and may only be constructed on a lot with at least one main dwelling unit. An ADU may be permitted on a lot with a duplex as long as there are only 4 units total in the development. Note that if an ADU is created and utilizes the more relaxed standards of the ADU ordinance, it will not be able to be converted to a non-ADU housing unit in the future unless it is reconstructed to meet the objective zoning standards for a non-ADU unit. An existing ADU can be converted to a dwelling unit as part of SB9 duplex development if it meets the qualifying criteria, including restrictions on demolition, alteration, and tenancy, and if the structure can meet the objective site development standards for the zone district and as required under SB9. Short-term rentals, housing units created or retained as part of an SB9 development through duplexes or lot split shall not be used as short-term rentals. Rental of any SB9 unit must be for a term longer than 30 days. Project denial findings. If a project meets applicable objective standards, unless deviation is necessary in order to allow for 2 units per lot of 800 square feet each, an SB9 housing development project may be denied if the building official makes a written finding based on a preponderance of evidence in the record that the project would have a specific adverse impact upon health and safety or the environment for which there is no satisfactory mitigation. California Environmental Quality Act, or CEQA, an SB9 housing development project requires ministerial review and is therefore not a project under CEQA. Coastal Act. SB9 housing development projects that are located within the coastal zone are subject to the regulations in the Coastal Act. Such projects, if not eligible for an exemption or exclusion, shall obtain approval of an administrative coastal permit. No public hearing, staff review only, prior to building a permit, issuance, or parcel map recordation. Dedications and off-site improvements. No dedications or off-site improvements shall be required with an SB9 project. Permit processing. SB9 housing projects do not require discretionary permits unless they are located within the coastal zone and are not eligible for an exemption or exclusion. If no coastal permit is required, planning staff will review SB9 projects as part of the building permit application process or the public works parcel map process. Planning staff may ask for additional information as part of the review to ensure compliance with objective standards and state law requirements. Fees. The applicant should contact the building department to obtain a fee estimate. If the project includes a land division, the applicant should also contact the Public Works Department for a fee estimate of a parcel map review and recordation. If you have any questions regarding SB9 and how it may affect you and your property right here in Santa Cruz, please feel free to reach out. I'm Shemeika Fox, your Santa Cruz real estate expert, and as always, I'm here to help.